Hello, this is Patty Joe. I am trying, actually, for a second time, actually, for a third time, to figure this whole thing out. We're going to do the second half of the 15-minute rant. I had to take a break. Yes, the break took me about a week because this guy is trash. But I think we all know that by now. So we're going to have a little bit of see if we can get all the way through the rest of this. This is I think I'm picking up pretty much the right spot of 31 and a half to 32 minutes, where he starts repeating a lot of the stuff for the third time, some of the stuff for the second and fourth time. Um, Hopefully, we can make it through and get on to some more pleasant things. Yes, I'm still rocking a prednisone moon face. I'm just trying to embrace the getting well situation. So let's move on. Those of you who are liking the shorts of my puppy, thank you very much. Her name is Harley. She is 5-year-old Siberian Husky. She is gorgy. She is such a little unicorn. She is so good. And people think she's so perfect, but she's still a dog. So she does all kinds of, stubborn, dramatic, husky dog things, and I'm going to try to get those because you guys seem to be enjoying those a lot. And I love doing it. I love watching her run around and do that. So moving on. Let's see if we can't stomach some more of the Darrell Brooks narcissist court case. I know he's had some other stuff. I'm hoping to find some of that so that we can move on with his dead future. Okay, so thank you, Fox 9 Minneapolis, St. Paul. Let's move it up forward. Let's make this bigger.
I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter.
Who's not a person? The plaintiff is the
I also
people.
have the right to
All of
challenge
us.
all relevant
All
laws
of them.
in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge,
if he spent half the time actually reading the material that she gave him in the beginning, because in the beginning of the court case, she gives him books with rules of evidence, how to procedures, how to do things to try and assist him. She doesn't have to do this. That's she being Judge Doro. She did it based on trying to make it as fair as possible to try to get him the information he needs. If he spent half the time looking at that he has spent putting together all of this rubbish, he may have come up with at least a semblance of mitigation or a defense or something, but he's got nothing. She says that in her remarks at the end, where she says, "I don't know if he was going to say he was afraid of the police. I don't know if he was going to say, he was confused. I don't know if he was going to say whatever he was going to. He didn't pick one and stick with it based on rules of evidence. He just was all over the map, and this is clear. Now I sound like him. This is him clearly, pushing that agenda forward. Clearly. Thank you, Darrell. Darrellism. Sorry, my computer lags. I don't have the greatest equipment.
the design
The design
of the statutes of the law was written for the common people to understand. So that would mean
How it means.
The final determination or interpretation of what the law says comes down to the people.
So what he's saying is, you don't determine what this means. I, in my twisted, narcissistic, completely uneducated, twisted interpretation, that's what it means. Okay, well, if I could walk into a court and say my speeding ticket doesn't mean what it means, then let's, I don't know. Wow. Wow. Hurting my head.
You know this, Your Honor. Are you not a public servant?
I hated when people would say that to me. Yes, I'm a public servant. Doesn't mean I'm your servant. And it doesn't mean I throw out my education to do that. What else do I know? Tell me what I know.
That this docket sheet is inaccurate.
Who cares?
Filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters.
This is meaningless.
Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that?
So you stop complaining?
Sudden change.
You're complaining?
I still have filings that have all capital letters.
Wait a minute.
Which I state every time I...
Okay. I always wondered how this man did this. You see this? He's not listening to this at all. He's like listening to an audiobook or something. Please tell me this man had a little bit of some kind of something to do like that. Oh my gosh. Because I couldn't do it. Listen,
come into your courtroom, Your Honor, that is
can't
not
even do
my
it for
name,
30 minutes.
nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client.
That makes no sense.
Did I accept for value in return for value? We go through this every time.
Yes, we do.
Every time I come here. Every time.
Let's see if I can try to be quiet.
You bringed up Illinois versus Allen.
Oh God.
When we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case.
It doesn't matter. She can do whatever she wants.
It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself?
Wasn't this case like from the mid 70s? She's just building on the technology that exists now, Darrell. You are just so fixated on twisting everything to be your way. Does anybody else have anything to say? I think I've covered that pretty much. Okay. Moving on quicker. Wish we could go through this faster. Sorry.
To add this 4th option to justify denying me my constitutional right by being present. You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case.
Can we do all 3 right now?
Nowhere does it say you can create a fourth option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason
Oh,
not to uphold your oath of office.
oh,
Treason.
oh my gosh. He repeats it. What, to make it true?
You repeatedly
Hold on. 120 pounds. 120 pounds. Is it true? No, it's not true. Okay, still not true. I still don't weigh what it says on my driver's license. We're still both liar.
Judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down.
No, you're just ignored. As you should be.
Which leads to today.
Oh, are we getting to the end?
The constant push not to have an informed jury.
Oh, the only one who doesn't want to inform the jury is you.
Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense.
Almost an argument. Almost.
You know also that you have an electronic filing system.
You know you have one. Okay. As an educator, when I was working for the college, a lot of times, 3 levels of education in EMS. I know one captain, I think he's still a captain in the Baltimore City Fire Department, who fancies himself like a really high-end educator, and he's a presenter, possibly an instructor level. Presenter being, I know how to present things. Instructor, I can kind of write my own stuff and instruct. He fancies himself the pinnacle of education. The problem with his assertion is he's not facilitating any of the learning of the people that he used to he loved to point out anything I would do wrong based on his very low standards. This is the same type of thing. He has definitely got a very low standard, and he wants everybody to dip to it. Hello, my name is Darrell. I think this way. You should all agree with me. Now let's move on. There's no facilitation of any kind of education process here. I don't even know where I was going with that. Let's move on. To rant.
I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately.
Because they do it correctly. Because they've read the book that was given to them.
Or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense.
Because you're doing it wrong. Do it right.
obviously the court knows that I'm not privileged to the same filing system.
That's meaningless.
Which brings me to the reason why I brought up the issue of assistance of counsel.
This is a
Under the
sophisticated
Sixth
argument.
Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of.
It also apparently does not say, and correct me if I'm wrong, I'm no attorney. It also does not say that as the client, you can dictate how somebody else does their job. Going back to civil service, yes, as a fire department personnel, I was a civil servant. Yes, you're correct. I am here to service those people on the streets, those who require my service. It does not mean that I throw out all the education I have. So, for example, I had a patient who had been struck by a car. And legitimately, he was struck by a car. The first time around, the engine couldn't find him. We could not find him in the medic unit. We could not find him. We called again to very close to that same location, but inside a house. Apparently, the folks from that house, who were basically squatters, took him from the street and carried him inside the house after he had been struck by his vehicle. Okay, so the patient himself, history of opioid addiction, heavy use, meaning he took lots and lots of drugs on a daily basis. That is the baseline that you're dealing with. But to move or not move a patient out of the street, I don't make judgments about that. That's what happened. Okay, so I actually arrived. That is what had happened. We finally did find him. He's on my couch now. He's screaming in pain. I cannot assess. I'm hesitant to move. I need to move him quickly within a 10-minute period at most, if I can. But he is making it extremely difficult with all of this extraneous information that he's giving me. I can't feel my feet. So his feet did not have shoes on it. So I took my two fingers, just like this, and his big toe, let's pretend this is a big toe, and I did this. Very little pressure, and he screamed as if I had lit him on fire. Then, of course, everybody whipped out the cameras, because that, of course, is helpful to nobody ever, and accuses me, and then he's threatening to kill me. Here comes the engine crew. And I'm like, look, everybody's. I am not making a judgment, but you were legitimately hit by a car. I see you have some injuries, and I have to make an assessment of what that is prior to moving you as quickly as possible, managing these injuries and managing your pain while getting you to the trauma center in a reasonable amount of time. You are preventing that with all of this extra stuff. I will be making sure that if you say you can't feel something or you are feeling something, I'm going to take my hands and take a look at that, or take a feel of that, see what is going on, feel what is going on. Do I feel anything broken? Do I feel any blood? Whatever it is, I'm going to do those things. I know they hurt. I'm going to try to handle that as well. I also know that you take drugs daily, which makes it hard for me to control your pain. I'm still going to try to do it. You have to take them for what they are. That is called civil service. It doesn't mean throw your education out and you don't do the assessment before you do the treatment. You still do it, whether they like it or not. It has to be done. I'm trying to be gentle and I'm trying to help you. As soon as we got on the same page, but we made real progress. That being said, I don't know how this person hit this man. He was wearing bay glow green clothes. You could see him from a block and a half away. The guy was really dressed to be seen at night. It was so sad. I think he's okay. I think he ended recovering. But yes, very difficult. Same thing. You don't throw out your education to be of service to these people, to every people, to all people. Sorry. Rant over. How long was that rant? It's longer than it. Sorry.
Counsel. Having counsel represent you and having assistance of
This is
counsel
very
is two
high
totally
level
different things.
thinking. I don't think he came up with
You,
it
Your
on
Honor,
his own.
gave me paperwork that was a waiver of counsel. We both know
We both
that
know
any contract can be altered
narcissistic. It's
if
not a
I don't agree to
contract.
certain terms. I crossed out everything
And
in
she
that
has to still
paperwork that
take
I did
it.
not agree or consent to, and specifically wrote on that paperwork that I do not
Okay, I'm
waive
gonna stop.
my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions
They're not your
together in a
secretary.
timely fashion. Make preparations
They don't have to throw out their
that I don't have
education
the
to do
privilege
it.
to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you
She has to by statute.
understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it.
By statute.
That is in the record. I have copies of
That's
the
my
same
understanding.
paperwork that you accepted. So when you accepted that, with no objection,
She doesn't have to
becomes a tacit
object.
agreement.
That's not a word.
But yet, I'm still forced to come in here with zero help.
They're all helping you. Jeez.
I
They're
think
all
it's
helping you.
clear
No.
that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial.
Oh, you want to be in general population?
Reference was made
I think we
to
should let
being
him.
able to use
Good idea.
LexisNexis or whatever it's called. We call it the law library.
Library.
The easier way to describe it. I'm only allowed to access the law library at certain times during the day.
Oh.
The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access.
Maybe that's what he wanted to be called, Frank.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which
as opposed to your speedy trial thing. Venue.
Even right now with trial going on, there's still political ads being shown every day that reference this incident.
So
there's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed.
I probably said this in the other one. I'm not sure if anybody disagrees with me. Could anybody suggest a venue where this would not have gone the exact same way? I mean, I don't have to be part of that community to really feel what this person did and look at these videos. I said this, I don't know if I've said it on video before, but what do they call this? Like spree crime where you commit crime after crime after crime after crime. That's how the prosecution describes at the end in her closing, where he just kept going and committing the same act over and over again. So I believe it would be a spree crime. If you're going to do that, doing it where the entire town gathers with cameras and video so that they can record the whole of it, plus any CCTV that exists or secured on these buildings. You did it in front of everything that can gather the evidence for them. When you want to see to look at a picture, you don't do it and take a picture of yourself and post it. Just, yes, that's what you've done. There's no other way to describe it. You just handed it to them on a silver platter.
Yet and still, that was denied.
Yeah, still that was denied.
It's impossible for impartial jury to be found in this county.
Or anywhere in the world.
And that's not to discredit people in the county that can be impartial. Mm-hmm. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this.
Yeah, cool. Should look them up.
The reporting live stream on Court TV has comment sections.
Cool.
Where a lot of insensitive and nasty things are said.
From whose
The
perspective?
sheer insensitivity of some of the things that are said on there.
Oh, is your little feelings hurt?
I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, is that I have children too.
Yeah.
Family too, loved ones too.
And they're ashamed of you too. And you
That
bully
also
them
have
too.
been ridiculed and had their names drugged to the mud and have threats towards them.
Didn't care about that when you were acting like that all those years.
Loved ones that had to leave their home because they were getting threats thrown through their mailbox.
Darrell, you're the one throwing them.
Children that didn't feel safe going to school because they were getting bullied behind what was being said.
Front of.
And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism.
So they thought it was.
And it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug.
Under the rug.
There's always going to be healing that has to take place.
Oh my goodness, here we go.
It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true.
What? It's not. Yeah. Sometimes I don't get to the point either.
I'm sure the court read through the motion for change of venue.
Oh my God.
I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious.
To where?
It's too many connections and it's too close. It's too close.
Again, if you're going to commit such an act in a small town with all of the act being recorded for posterity from 800 different angles, I'm 100% sure. Okay, that's an absolute. I am 99.7% sure that some of these things had more than one video that captured the same couple of seconds, minute, or whatever. It doesn't matter where you went. The evidence would have followed you there, and it just would have cost tons of money to do that. Change of venue apparently was just not going to be helpful to you whatsoever. They asked for it because they were supposed to. Good for them. Moving on.
If there was any chance for a fair trial and an impartial jury, it should not have been.
My
in
head
this
hurts.
case. But yet it was denied.
Oh gosh.
Without any validity.
We're almost done, please.
Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet.
And a docket sheet.
We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship.
Who cares about it?
No matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof?
Where's the proof? Nobody has to prove anything to you,
Ask
Darrell.
that same question. Can an affidavit be given
No.
that there is no bias, no conflict of interest, and no interest in the outcome of this case?
That's called an appeal. Isn't that called an appeal? Somebody help me with that.
There's no proof if you hold the full judicial power of the state, or is it the military power?
Meaningless.
Mr. Brooks, I've given you about 15
Thank you. Hallelujah.
arguments. You've now repeated yourself
55
a
minutes.
number of times.
Thank you.
So I'm going to turn to the state to see if they have any response.
Okay, before we let her respond, I'm just going to say this. He said their things are prepared. Even when you stop her at an odd place, she still looks beautiful. Very well done. I wish you are just the pinnacle of professional as far as I'm concerned. Lovely lady. Okay. They sound polished. They sound prepared because they've practiced doing this on the fly all the time. I love the glasses on her. She just looks so
Go ahead.
professional.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847 Fed 3rd 559 on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly.
Shut up. You interrupt immediately.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court
2 weeks ago.
whatever it was, 2 weeks ago.
Yep.
Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender.
I believe it's after this. Now, I know I'm going like all over the map, but I actually did watch this in real time, which I could not follow. I was thinking about doing the videos back then, and I saw all these people doing them, and I decided it was too late. I couldn't bring myself to do it until I knew he was going to be convicted, because he was so disgusting. But it was soon after this rant that all of a sudden he couldn't find his homework. Issues come up, and I know a lot of you have seen some of those videos too, where he said, "I can't find the file, and we can't move on until I can find the file." He logged on to anything these people say, the prosecutor, the judge, anybody, and he twists it and pulls it in and shifts it. Like, it's incredible. But this actually, I didn't notice it at first, but it was after this that he started playing that little game as well. You can tell me if I'm right.
Know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back.
At all.
They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety,
Yes.
so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex rel. George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law
Paralegal
school
training.
education.
Oh my God.
The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit.
Yep.
Much of the last 50 minutes, which this court has graciously extended him
Painfully.
the opportunity to go on and on.
Use the right word.
Is
Okay. They gracious, painful. It was painful. And they keep saying, letting him say objection, where it should just say interruption. Interruption, because that's what he's trying to do.
nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay,
Yes.
disrupt, intimidate,
Yes.
and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
She could have said the same thing. Oh, wait a minute. She just did, except for hers was eloquent.
My opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Institutionalization. That's what I call that.
For her to
That's
sit
not how
there-
this works.
For her to
That's
sit
not how
there-
that's.
Objection is noted.
For her to sit there, Your
No,
Honor.
it's my
No,
turn. Let me,
you don't get to
let
talk.
me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive. They come to this court, as the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact.
I wasn't going to interrupt her because she is so eloquent, but I used to do this a lot with students. Basically say, and this is where I was going with that captain in the fire department, when they would ask a question, when they want me to reconsider my decisions on things or decisions based in rules that I was drawing that they had no idea about, I would want to facilitate them. I would want to encourage their advocacy of themselves, rather than just beat them down like this captain does. And I would basically tell them this: you're asking the wrong question. Because if they had asked a different question or asked the question in a different way, there usually is an argument. And that's what I'm saying about Darrell. There could possibly, potentially be arguments here. But lawyers think in a different way. Attorneys are trained to put things together in a way that brings it from the breadcrumb to the conclusion without stating it so that you are drawn to this conclusion as well. That is the situation. And she is very eloquent here in doing this exact thing, where she is just saying, basically, you're asking the wrong question, and nobody here is going to help you ask the right one. My apologies.
There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal.
Yes.
It is true. You have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted. The record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always
shut
do
you
that,
up.
but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum, and that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raised concerning your right to assistance of counsel, the record before this court over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further.
Thank you.
Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time, so I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, we didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. It still hasn't been.
Objection is noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr.
any
Brooks,
proof.
I've addressed them
There
to the
still
extent
hasn't
that
been
I
any
will.
proof. There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said, that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's
It's
anything
not.
along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
Because there's no verified proof.
There does not need to be, sir. All right, I
does
believe the
need to
jury
be.
is.
No, there
hung
it
up.
doesn't.
In order for a case to,
All right, the
To
record
go
should
on, there should
reflect
be
that the
proof.
jury is coming out and we are about to continue with the state's next
not once
witness.
was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
I understand.
made by the defendant.
I see.
It is not his opportunity to testify.
I see what's
They are
going on.
comments and as such are to be disregarded.
I see what's going on.
Because he doesn't like it, he's going to continue with
All right.
this
Thank you,
childish
everyone.
behavior.
You may be seated.
Okay. So let's see.
we are Back on the record.
So he continues on with his childish behavior because he doesn't get his way. That is the way he does it. I'm glad we all made it through this. If you made it through, great. Like, subscribe, share. Please let's discussion with some of the less, I don't know, talked about things, the narcissistic behaviors, something like that. Let's move on. If you're, I want you to have a great weekend, a solid weekend. If you're doing something for motorcycles or dogs or your family or whatever it is you're doing, be safe out there. Have a great weekend. Have a great time. Very safe time. Thank you very much for your attention.